Building upon the previous discussion of the statutory conditions that make a timeshare transaction rescindable, it is essential to explore the detailed rights, procedures, and responsibilities involved when a purchaser exercises their right of rescission. Arizona law, particularly ARS, Section 32,219 7.03, 19 outlines precise timelines and methods that govern how and when a purchaser may cancel a timeshare contract, as well as how the developer must respond. Understanding this process ensures that both buyers and real estate professionals act within the boundaries of the law, protecting consumer rights while maintaining fairness in the marketplace. Under Arizona's Timeshare Act, every purchaser is entitled to an unconditional 10 calendar day right of rescission, beginning either on the date the purchaser signs the contract or the date the purchaser receives all required disclosures and the public report, whichever occurs later. This statutory cooling-off period provides consumers the opportunity to review the transaction outside of a high-pressure sales environment. The rescission right exists regardless of the reason for cancellation. The purchaser is not required to justify their decision, and the developer may not impose any penalties, forfeitures, or fees for exercising this right. The law is equally specific about how a purchaser may rescind. Under ARS Section 2-2-197.03b, the buyer must deliver a written notice of cancellation to the developer within the 10-day timeframe. This written notice must clearly state the purchaser's intent to cancel the contract, but it does not require any particular wording or form. The communication may be transmitted through any means that ensures proof of delivery, commonly via certified mail, personal delivery, or electronic transmission, if permitted by the contract. What matters is that the notice reaches the developer within the statutory timeframe, not necessarily that the developer acknowledges it immediately. For example, if a purchaser mails a cancellation letter on the 10th day, but the developer receives it 2 days later, the rescission remains valid because the notice was sent within the legally required period. Courts have consistently upheld that the act of mailing, not receipt, determines compliance, similar to the mailbox rule used in contract law. Once the developer receives the notice, ARS Section 32-197.03c requires a full refund of all monies paid, including deposits, down payments, and any other consideration. The specific 15 business day refund requirement, that language is not found in the core timeshare rescission statutes themselves, e.g., Sections 32-2197.03 or 32-2197.05, but may reflect a contractual term or interpretation in case law or administrative rule concerning handling of escrow funds after cancellation. The refund must be unconditional, and the developer cannot attempt to renegotiate, delay payment, or offer alternate incentives to discourage rescission. This rule ensures that the rescission process remains clean, swift, and free from further sales influence. Consider a real-world example. A couple purchases a timeshare interest in a Sedona resort during a weekend presentation, paying a $1,000 deposit. 2 days later, after reviewing the public report, they decide to cancel. They draft a letter stating, "We are exercising our right to rescind our timeshare purchase agreement dated March 3rd, and send it via certified mail on March 5th. The developer receives the letter on March 8th and must refund the $1,000. If the refund is not issued, the purchaser has grounds to file a complaint with the Arizona Department of Real Estate, ADRI, or pursue civil remedies. An important element of this process is the disclosure obligation imposed on developers. Every timeshare purchase contract must include, in bold and conspicuous type, a statement informing the purchaser of their right to rescind. This statement must specify the rescission period, instructions for submitting notice, and the address of the developer or escrow agent designated to receive cancellations. Failure to include this language renders the contract non-compliant, and may be grounds for administrative penalties or purchaser remedies under ARS. Section 32-2197.03b. In Miller v. Sedona Pines Resort, LLC, 2009, the Arizona Court of Appeals reaffirmed that any contract lacking clear notice of rescission rights violates statutory law. The developer in that case had included rescission information in small print, buried among other terms, failing to make it prominent as required. The court ruled that the developer's omission constituted a material misrepresentation, granting the purchasers a full refund, and establishing that the rescission notice must be clear, bold, and conspicuous to be enforceable. Arizona's rescission framework also interacts with federal law under the Federal Trade Commission, FTC, timeshare rule, which imposes similar cooling-off protections for interstate timeshare sales. However, Arizona's statute provides more robust safeguards by mandating both disclosure and refund procedures. It's important to note that the 10-day rescission right applies to both in-state and out-of-state timeshares sold to Arizona residents. If a developer markets to or offers timeshares to Arizona residents, the protections and requirements of the Arizona Timeshare Act apply, even if the property is outside Arizona. Review summary: Arizona's timeshare rescission process is designed to protect consumers from pressure-driven or uninformed decisions. Purchasers have 7 calendar days from signing or receiving disclosures to rescind a contract by written notice. Developers must refund all monies within 15 business days and cannot impose penalties or deterrents. Each contract must contain a clear and conspicuous rescission clause, informing the buyer of their rights. Violations, such as failing to issue timely refunds or omitting rescission disclosures, constitute grounds for adverse enforcement and civil remedies. Discussion prompts. Why is it important that rescission rights cannot be waived or shortened by contract? Answer: to preserve consumer protection and prevent developers from using contract language to limit statutory safeguards. What should a developer do upon receiving a rescission notice from a purchaser? Answer: immediately cease all sales-related communication and refund the buyer's money. How does ADRU ensure compliance with rescission rights? Answer: through administrative review, enforcement actions, and penalties for developers who fail to disclose or honor rescission procedures. Closing remarks. The rescission rights provided to Arizona timeshare purchasers represent the state's strong stance on consumer fairness and transparency. These laws ensure that every buyer has time to reflect, consult with trusted advisors, and make informed choices free from high-pressure tactics. For real estate licensees and developers, compliance is not only a legal duty, but a reflection of professionalism and integrity. Upholding these standards fosters public trust and protects the long-term health of Arizona's real estate industry.